Welcome everyone to today's virtual panel discussion on existing legal limits to the Security Council use of veto during situations of mass atrocities, which is co-hosted by the Center for Geopolitics at the University of Cambridge and the Program on International Peace and Security at the University of Oxford, Levenick School of Government. My name is Federica D'Alessandra, and I'm the Executive Director of the Oxford Program on International Peace and Security. I was going to be one of your panelists today. However, due to unforeseen circumstances, our scheduled convener, Dr. Thomas Peake of the Center for Geopolitics, could no longer join us. And for this reason, I will be chairing today's discussion instead. Just a few days ago, on October 24th, we celebrated the 75th anniversary of the entry into force of the UN Charter. Article 24.2 of the Charter confers the UN Security Council its powers and primary responsibility vis-a-vis the enforcement and maintenance and restoration as well of international peace and security. This responsibility is, however, not exclusive, and under the Charter, other UN bodies, such as the UN General Assembly under Chapter 4, and particularly under Chapter 11, under Article 11, the Secretary General under Article 99, they also share complementary and residual responsibilities vis-a-vis international peace and security. In 2005, in a historic gathering of world leaders at the high-level plenary meeting of the General Assembly, also known as the 2005 World Summit, heads of states and governments also agreed to what is called the responsibility to protect, which is exactly a responsibility to protect populations from genocide, war crimes, crimes against humanity, and ethnic cleansing. The outcome document of the summit, which addressed this responsibility, this norm, in paragraph 138 and 139, was unanimously adopted by all UN member states. However, today, atrocities are widely, and atrocities today are widely recognized also to be international peace and threats to international peace and security. And as such, they've been on the Security Council agenda for over 2 decades. Yet, 75 years after the creation of the United Nations and 15 years after the adoption of the responsibility to protect, the Security Council continues to fail to take appropriate and timely action in the face of atrocity. Even worse than passive inaction is the repeated use or the threat of the use of veto from veto powers from the permanent members of the Security Council. The ongoing tragedy in Syria, which has seen 14 Russian vetoes that have blocked Security Council resolutions aimed to prevent further atrocities and assisting civilians in need, is perhaps the worst, if not, but unfortunately not the only example of this. I think it is a very clear example of the type of human suffering that the veto really can contribute to. And despite many calls for reform and appeals for veto restraint that actually date back to the 1950s, a change in pace at the Security Council remains elusive at the moment. So building on the conversations held in this series in June, to which I participated alongside Senator General Romeo Dallaire and Ambassador Stephen Rapp, in which we broke down the dynamics of the use of veto. Today, we have reconvened a panel to explore actually the legal and ethical issues that underpin the use of veto, but also discuss potential solutions and where, as an international community and as an organization, the UN as an organization should go from here. We are joined in this panel by 3 of the world's foremost experts in international law and international relations that will offer thoughtful remarks to guide our reflections on the issues. Professor Jennifer Trahan is a clinical professor at New York University Center for Global Affairs and the director of the Concentration in International Law and Human Rights at NYU. She recently published a landmark study on the legal limits of the use of veto in situation of mass atrocities, which won the Best Book of the Year award by the American branch of the International Law Association. And she will speak first, presenting the arguments of the book. After her, we will hear from Professor Jennifer Walsh, who is the Canada 150 Research Chair in Global Governance and Security and the Director of the Center for International Peace and Security Studies at McGill University. Professor Walsh, who served as UN Assistant Secretary General and Special Advisor on the Responsibility to Protect, will discuss some of her own recent research and thinking on this issue, and particularly in the political dynamics of the use of veto, but also she will offer some insight on the type of issues that arose around discussions on the French, Mexican, and Accountability, Coherence, and Transparency Group proposals, which were proposals for restraining the use of veto around 2014 and 15. Last but not in no way least, we will also hear from Professor Mark Weller, who is the Chair of International Law and International Constitutional Studies at the University of Cambridge, who will offer his comments and responses to the thoughts offered by the previous two panelists. So this really promises to be a very insightful discussion. I want to thank our panelists and everyone in the audience who's joining us from all around the world. I encourage everyone in the audience to submit questions through the Q&A button at the bottom of your screen. Simply type in your questions in the box and they'll be directed to us. Please do note that whether or not your question is directed to a specific panel member, and please also add your name and university or other affiliation if you have one. And now, without further ado, I would like to invite Professor Jennifer Trahan to take the floor and get us started. Jennifer, thank you so much for being with us.
Great, thank you, Federica, and thank you so much for last minute stepping in and filling in and suddenly converting to our moderator. I also would like to thank Dr. Thomas Peake, who worked hard to organize this panel and then last minute wasn't able to join us today. And I would like to also thank the Oxford University Blavatnik School of Government and the Cambridge University Center for Geopolitics for co-sponsoring this panel. So today I'm going to lay out what I think firstly is the problem we're talking about. Then I'm going to talk about my legal arguments, how to address the problem, and I'm going to conclude with 3 concrete steps that states could be taking right now to help alleviate this quagmire. So one of the premises of my book is that the veto use in the face of ongoing atrocity crimes, and when I use atrocity crimes, that is shorthand for genocide, war crimes, crimes against humanity. This veto use is at odds with various aspects of our system of international law and continues to violate people's rights and fuels current cycles of violence around the globe. So let me give you some examples. Historically, during the apartheid regime in South Africa, we have 3 vetoing permanent member states that arguably delayed the dismantlement of apartheid. They did not completely block the Security Council, which was able eventually to impose mandatory sanctions. During the Rwanda genocide, we have something slightly different. We have veto threats. And it's actually the same 3 permanent members don't want the word genocide used, and they refuse to send added peacekeeping forces, at least during the height of the killing. Regarding Darfur, Sri Lanka, and Myanmar, we again have more the veto threat. And the veto threat can bring the council to a halt just as effectively as a veto. The threat is not something made in threatening language, but it is a permanent member's objection to certain wording, certain provisions, letting the other council members know they would invoke their veto. We also have somewhat of a parallel problem of self-censorship. So today we are not discussing a proposal for an ad hoc tribunal for Myanmar, because no one has bothered to draft such a resolution knowing that it would be vetoed. So there's also self-censorship. Not drafting resolutions that are known not to be able to pass because of the veto power. And regarding Myanmar, there was actually one veto in 2007 that would have then condemned the crimes. And if you can't condemn the crimes, the council certainly isn't going to be able to ratchet up and impose its other measures. And what the failure of condemnation does, it also sends a proverbial green light to perpetrators on the ground that they have a protector on the council. The US frequently uses its veto related to Israel, and my arguments do pertain to all veto use in the face of atrocity crimes. My book contains particularly detailed chronologies related to Syria and Darfur. Syria, because we see by now, my book discussed 14. By now, we have a series of 16 dispiriting vetoes in the face of atrocity crimes. And Darfur, we have veto threats. But looking at the situation in Darfur, what you see is at a time period, you have accelerating crimes and accelerating death tolls. What you have are council resolutions blocked so that sanctions are weakened, so that the peacekeeping mandate is weakened and peacekeeping deployment is deferred. Regarding Syria, the vetoes there, all again in the face of mounting atrocities and mounting death tolls, prevent recognition of various crimes. They block referral of the situation to the International Criminal Court. They block a variety of chemical weapons related proposals, including the joint investigative mechanism that would have attributed responsibility to the side using the chemical weapons, and they even block humanitarian assistance. And just note on this, the chemical weapons inspection one, we have a fairly clear correlation that when these inspections start, we have decreased chemical weapons use on the ground, and after the 3 vetoes of the chemical weapons inspection regime, we have accelerated use of chemical weapons. So on that one, I think we have a fairly clear correlation between voting on the East River, the veto on the East River, and fatalities on the ground. Put together, it is fairly clear that this series of veto use and veto threats in situations of ongoing atrocity crimes, where there are the required 9 votes to otherwise enable the council to take some kind of measures to alleviate the commission of atrocity crimes, this veto use is costing lives. So my book asks the reader to look at this practice in light of the obligations of our system of international law. And I have 3 independent arguments. My first one is based on jus cogens. So we say that genocide, war crimes, crimes against humanity are peremptory norms of international law from which no derogations are permitted. They are thus protected at this very highest level that we call jus cogens. Now, the veto power is found within the UN Charter. The Charter doesn't say the word veto, but it is in 27.3, which requires positive votes from the permanent members, now read to mean positive votes or abstention. In other words, not a negative vote. So I have 3 independent arguments related to the first argument, that firstly, it is inconsistent to say that these crimes are protected at our very highest level of law, yet a lower source of authority allows blockage of measures related to these crimes. At minimum, it is inconsistent. And here I draw on the harmonious interpretation doctrine of the European Court of Human Rights. And I know they were looking at a different question, but I do draw on that. And shouldn't we have harmonious interpretation or even harmonious resolution between the Security Council and our highest level of law? A more aggressive formulation of this argument is some of our vetoes are actually facilitating atrocity crimes. And if you look at how they play out, it does appear to be the case. Another way of formulating this is it is a violation of the ILC Articles on the Responsibility of States for Internationally Wrongful Acts. Article 41.1 recognizes a duty of states to cooperate to bring to an end through lawful means any serious breach of an obligation arising under a peremptory norm of general international law. So states are at minimum also violating this duty recognized by the International Law Commission. My second argument relates to the position of the veto in the context of the UN Charter. So the UN Charter is framed in terms of its purposes and principles in Articles 1 and 2. And these require all member states to respect international law, human rights, the obligation of good faith, and mandate cooperation in solving international problems of a humanitarian character. Under Article 24.2 of the Charter, the Security Council as a whole is obligated to respect the purposes and principles of the Charter. But individual states also have to respect the Charter. And permanent members are both individual states in their individual capacity, and when serving on the Security Council, if the Security Council as a whole is bound, then they necessarily must be bound as well, because individual permanent members cannot have power that would be greater than the power of the Security Council as a whole. Put together, their vetoes, their actions and inactions need to be judged against the UN Charter. And this is an argument that states have often invoked at times invoked, and I compiled some of their statements in my book. They seem to agree that the vetoes we're seeing seem out of line with UN Charter. And the third argument is based on treaty obligations. So under the Genocide Convention, Article 1, we have the obligation to prevent genocide. And under Common Article 1 of the 1949 Geneva Conventions, we have the obligation to ensure respect for the Geneva Conventions. The obligation to prevent genocide was given quite a broad content in the Bosnia-Serbia case of the ICJ, which says, first, your obligations are triggered when there is a serious risk of crimes. They're not just triggered when the genocide is happening, but the serious risk. And here it imposes a capacity to, a due diligence obligation based on a state's capacity to influence. It must use the means at its disposal. Well, permanent member states have particularly strong means at their disposal by virtue of their position on the Security Council. They also often have bilateral relationships with the country in question, and they should be using these in order to satisfy this obligation. The Bosnia-Serbia case tells us it's also not just an internal obligation. It is not that a country only must prevent genocide within its own territory, but note in the Bosnia-Serbia decision was, of course, the obligations of Serbia vis-a-vis genocide in Srebrenica. So the court is clear, it is an extraterritorial obligation. These same basic propositions are true of Common Article 1, the obligation to ensure respect for the Geneva Conventions. It is a due diligence obligation, and the ICJ in the Wall and Nicaragua cases holds that it is also this kind of external obligation. It is not just to observe the Geneva Conventions within a state's own territory, but externally as well. It may be difficult to tell what exactly is required of due diligence, but I will argue that the vetoes we see are the antithesis of due diligence. So the vetoes are at odds with these aspects of our system of international law, and states can take three concrete measures. They can invoke whenever possible these kinds of arguments questioning the legality of some of the vetoes being cast, not just voluntary veto restraint, which has been fairly widely endorsed, but I don't think it goes far enough when 3 permanent members do not endorse it. So I think we need to move to the next step of looking at these legality questions, and I think they would be particularly helpful for the elected 10 members on the council or permanent members who are trying to stave off a veto of another permanent member. In this way, states can continue to build on the very clear precedent that has been articulated that states do not condone how the veto is being used in the face of atrocity crimes, which we see clearly in the French-Mexican Initiative, an active code of conduct, which Jennifer Welsh will expand on. Second step, states could work to have the General Assembly issue a resolution reflecting these requirements of international law, and or they could consider asking for an advisory opinion of the International Court of Justice that it would opine on the legality of a permanent member using its veto to block measures and thereby enable the continued perpetration of atrocity crimes. So I will stop here and eagerly await my panelists' remarks. Thank you, Federica.
Thank you, Jennifer, so much for such a comprehensive overview of the arguments that you've set out. I must say, I personally am very grateful for the analysis and the framework that you set out in your book, because I think that is exactly the type of framework that was needed to introduce some nuance in the conversation on veto powers. And that is because this has been a controversial issue, right? On the one hand, it's important to acknowledge that there is no indication in the drafting history of the UN Charter that the veto powers were designed to ever be used in such a way that would block action in the face of mass atrocities. But at the same time, because there is no rule of international law that specifically addresses the limits of the use of veto powers, there have been really split views among international lawyers, and I think international relations scholars for that matter, on whether any limits exist at all. And I think that what you've achieved with this work is that you've introduced a much needed nuance in the discussion. I personally take the view, like you do, that veto powers are not unbound. And I wanna congratulate you especially for highlighting the role played by Jus Cogens norms, the purpose of principles in the United Nations, articulated in Article 1.1, and also for evaluating the legality of the use of veto in the face of the commission of genocide, crimes against humanity, and war crimes by breaking down the analysis, looking both at collective responsibility of the UN Security Council as a whole, but also at individual responsibility of its member states, and specifically by referring to the hard law obligations that underpin the responsibility to protect, that essentially bind all member states based on the treaties to which they are their parties, and also based on customary international law. So I will now like to actually introduce Professor Jennifer Welsh to take the floor and offer her thoughts on some of the dynamics really that underpin the use of veto within the Security Council, but also some insight in terms of the initiatives that Professor Jennifer Trahan referred to in terms of proposals for voluntary veto restraint.
Great, thank you very much, Federica, and thank you to the Center for Geopolitics at Cambridge. It's a real pleasure to be part of the panel discussing Jennifer's book, but also an issue that was very much discussed in the period that I acted as special advisor on the responsibility to protect between 2013 and 2016. And maybe we should make it easier, since there's a few Jennifers on this panel, that we talk about JT and JW to know who we're talking about here. I'd like to do three things. One, I just wanted to introduce how we might think about this issue within the context of the responsibility to protect. And then secondly, I wanted to make just a couple of comments on JT's arguments in her book, her legal analysis, and her observations about the consequences of the veto. And then I wanted to thirdly go through a few of the issues that come out of the three different proposals for restraint of the use of the veto, as I see them. And then lastly, if I have time, just to point out a couple of diplomatic quandaries that I think emerge from the quest to restrain the use of the veto. So firstly, I think the best way to think about the responsibility to protect is as a political principle that reinforces existing legal obligations. And as a political principle, it was really designed to do three things: to build institutional capacity, firstly, to prevent and respond to atrocity crimes at a number of different levels, not just within the UN, but within regional organizations, individual member states, etc. Secondly, to mobilize the will to consider and act in atrocity crime situations. And then thirdly, to raise the political costs of inaction. And I think the second and third of these roles is really are really implicated by the issue we're discussing today. Because I think one of the things to remember about the so-called third pillar of the responsibility to protect is that it is the part of that norm or principle that entails collective action. So it's very different from other kinds of norms we talk about internationally, the norm against torture, the norm of prosecuting alleged perpetrators, which are about individual states doing things. The third pillar is about the prescription to act collectively to address atrocity crimes. And what I see the Article 139 of the Summit Outcome document as doing is firstly creating a sort of duty of conduct for the members of the Security Council to consider atrocity crimes on a case-by-case basis, not with a predetermined outcome of what action will be taken, but simply to consider those instances in its deliberations. And then secondly, it's calling upon the council to take timely and decisive action. And in a sense, this restraint of the use of the veto is really only dealing with the second issue, timely and decisive action. But I think you could argue that an equally significant problem that we face today, aside from veto use, is simply having atrocity crime situations discussed actively by the Security Council. If we think of cases of Sri Lanka, Venezuela, Myanmar, the issue wasn't veto use. The issue was that the council or particular states prevented these situations from being discussed on the council's agenda. And I'll come back to that question a little bit later when I talk about the individual proposals. Secondly, Jennifer's legal analysis. I found this really fascinating, her three different arguments about how we can think about the responsibility not to veto. But I just had a couple of questions, I guess, arising, mainly questions for her. Firstly, with respect to the claim that the veto is subordinate to jus cogens norms, I wonder if this argument is stronger with respect to genocide than it is with respect to war crimes. I constantly felt in my role as special advisor that when we thought about atrocity crimes in relation to the responsibility to protect, we often thought only about one of those atrocity crimes. We frequently focused on genocide, but the principle was designed to look at 4 different atrocity crimes. And I just wonder whether the strength of your first argument depends on the type of atrocity crime that we're considering. And then thirdly, with respect to your third argument about the obligations of the Genocide Convention, the question I really have coming out of your legal analysis is whether there's a legal obligation to cooperate, which is what you seem to be saying, because that's what the veto use is really about. It's about preventing collective action. It's about preventing cooperation. And it seems a leap to me to talk about individual obligations in the Genocide Convention to talking about the obligation to cooperate. I know that there's been some discussion of this in legal analysis, but it seems to me that's what we should be focused on, is whether there's really a legal obligation to cooperate to address atrocity crimes. Also, I just wanted to make a couple of comments about your discussion of the implications of veto use. I think you're absolutely right that it contributes to a decline in council legitimacy. I won't elaborate on this. I think it's also right, and this is something we might discuss in Q&A, that it's led to a rebalancing of institutions within the UN framework. So we see a reconsideration of the General Assembly's role, the potential for it to take on certain types of innovative solutions like the IIIM to dealing with atrocity crimes. But your third argument that it's likely to make it more possible and more frequent that states will engage in unilateral humanitarian intervention, I was less convinced. I was less convinced about the empirical evidence for that and whether that's really a significant consequence. So I would love to hear a little bit more about that. So secondly, let me just talk about the 3 diplomatic efforts that have been undertaken to encourage restraint in the use of the veto. And the first, as you will know, was the French government's initiative to call for the permanent 5 members of the Security Council to exercise restraint where their vital interests were not at stake in situations featuring atrocity crimes. And this became a French-Mexican initiative. And I think the most interesting part of that initial proposal was that it had a procedural trigger, which was that at the request of at least 50 members of the General Assembly, the UN Secretary General would be called upon to determine the nature of the situation and whether it constituted a situation of atrocity crimes. And I will say here that I think this elevated a really thorny issue for the UN Secretariat and the Secretary General's role. And I think that this issue is even more important today than it was in 2013 when this issue was discussed. And that is that, in a sense, the French and the Mexicans were asking the Secretary General to play a quasi-judicial function to determine whether a situation involved atrocity crimes. And given the other roles that the SG needs to play, particularly his or her good offices function, the need for impartiality, this was a real concern among members of the UN Secretariat about whether this was an appropriate role for the Secretary General to be playing. I remember as well, there was discussion among member states around whether, if not the SG, maybe some other kind of expert body, or at one point, a discussion that it should be the Joint Office for the Prevention of Genocide or the Responsibility to Protect who should make that determination. And I'll just share with you a funny comment that arose in that context, where a diplomat said to me, you know, if that were the case, Jennifer, we would be paying a lot more attention to how those in your role get selected, right? Because if you're going to be asked to play this quasi-judicial function, what are the implications for how states may contest the appointment of particular types of officials in the UN system? So I think that procedural trigger gave host to a variety of diplomatic discussions and really consternation about how we should think about the different roles of actors within the UN system. Secondly, the Code of Conduct of the Accountability, Coherence, and Transparency Group, it called upon all members of the Council, elected and permanent, to not vote against any credible draft resolution intended to prevent or halt mass atrocities. And it has been signed by a number of states, by my last count, 118 member states of the UN system. And I think this is an extremely interesting proposal for 2 reasons. Firstly, it requires or asks states to explain their rationale for their use of the veto. So it's appealing here to the power of argumentation in shifting behavior. But secondly, it does call again upon the Secretary General using the expertise and early warning capacities of the UN system to continue to bring to the attention of the Council situations that involve or are likely to lead to atrocity crimes. So there's an implicit call here to use Article 99 more explicitly. But again, I think there was an issue that arose with respect to the Act proposal, and that is that it largely relies on what it calls the facts on the ground to instigate Security Council action and discussion. And I think one of the issues that's become clear in at least the discourse among states is the epistemic uncertainty as to whether situations really do feature atrocity crimes. Obviously, this was for reasons of political theater, but if you go back to the UN Security Council debate over the referral of Syria to the ICC in May 2014, one of the arguments of the Russian permanent rep at the time was that a lot of the French evidence that it was putting on the table was fake, right? This is fake evidence. This isn't real. How can we be certain that these acts are occurring? So the facts of the ground are not always obvious to all member states. Frederica, I think I'm running out of time, so I just wanted to say two last things. The third diplomatic effort that we saw in relation to the restraint of the veto was, of course, from the elders. And I think their proposal was much more directed at encouraging a spirit of dialogue and collaboration rather than some sort of formal enforceable mechanism within the council. So the elders stated that when using the veto, permanent 5 members must not only explain their decision, but propose an alternative plan that could achieve the same goals. So here they were appealing to concerns about the implications of particular proposals for international peace and security, which is the council's remit. But I personally saw this as a very productive formulation because it was asking those using the veto to propose an alternative solution to try to find common ground. And that is what struck me as a strong point of that. I just wanted to close though with some observations about how asking all members of the council to restrain either their use of the veto or their negative votes can affect power dynamics within the Security Council, and why weaker states might be reticent to sign on to the Act Code of Conduct. And I think it's because it would impose restraint that would further undermine, in the case of non-permanent members, their own limited power. So the flip side of collective action here is collective restraint. And that's what ACT is asking for. But of course, collective restraint, if you assume that that is a good thing, it also assumes that power asymmetries, in a sense, can be resolved. And I think a lot of weaker states worry that they give up the one sort of leverage they have. You know, most Security Council votes take place after the permanent members have been in a room by themselves, negotiated the text, and asked non-permanent members to vote on it. The one thing that non-permanent members can do to exert some leverage is not give indication of how they're going to vote. And so by pre-committing, you could argue that this actually reinforces power asymmetries. But I'll stop there. It's a fascinating issue of not just law, but also politics. And I look forward to the discussion.
Thank you so much, Jennifer. Really so much food for thought. I will spare my thoughts for the moment because I want to give Professor Mark Ballard an opportunity to come in, and hopefully we can discuss some of the points you raised later on. Mark, the floor is all yours. And by the way, thank you both for being with us.
Thank you so much. Congratulations, Jennifer, 1, on your wonderful book. And thank you, Jennifer, 2, for your illuminating and in some sense slightly more hesitant and therefore also thought-provoking comments. 3 areas of interest for me. 1, to consider the concepts of mass atrocities and the veto, which is our topic today, I think officially. 2nd, voting in the Security Council, a few legal thoughts, and that relates also to the Jus-Cogens dimension. And finally, what are the kind of steps one could take, in part, amplifying the proposals that both Jennifers have just told us about. Mass atrocities, both of our first speakers today seem to be using the term mass atrocity. Jennifer referred to the Mexican initiative Atrocity Crimes, and Jennifer 1 mentioned that mass atrocity is expressly the same as genocide, crimes against humanity, and so forth, the 4 crimes that were identified in responsibility to protect, or the types of crimes. And I wonder whether that is always helpful, because the idea of mass atrocity is one of consequence, something that can be observed. It is a fact. We have so and so many numbers of deaths, torture, systematic violations of human dignity, human life, human integrity. or perhaps also activities that wouldn't necessarily be covered by concepts like genocide, mass starvation, which is not being effectively answered. So I was slightly sad when I saw that responsibility to protect moved away from the concept we had earlier, which was the idea of an overwhelming humanitarian emergency, to a legal concept of genocide, crimes against humanity, where, as we saw in all of the cases that Jennifer One mentioned, there has been considerable debate as to whether these concepts apply or not, both amongst politicians and perhaps for political reasons, but also amongst the often well-meaning lawyers. So I retain some sympathy for the actual title of this panel, which I thought was Mass Atrocities. And I would just invite us to consider whether that actually is necessarily the same as the far more narrowly defined technical legal concepts. I see why Jennifer One needs to refer to them, because the Jus-Cogens argument depends on that. But it's just something to point to. What is it? Is it the number of victims, the magnitude of suffering? Is it the fact that a government is attacking a population which it purports to represent, or perhaps just an effective authority does so, that we need in addition to the suffering of population? Is it the legal qualification of the situation as genocide, crimes against humanity? My own sense remains that the essence should remain the magnitude of suffering as was expressed first in the famous Somalia resolution, where the Security Council determined that the magnitude of suffering of the people of Somalia amounted to a threat to the peace, and therefore opened up an avenue for action of the UN Security Council under Chapter 7. Happily, no issue of the veto arose then. Then, secondly, the veto. Yeah, again, one can think about it further. Is a veto a situation where one single state obstructs the adoption of the resolution? We have an alliance, a formal declaration of political cooperation between China and Russia, where after Libya, they agreed that they would cooperate in their policy on situations of this kind. And in Syria and one or two other cases, I think, we have seen them act together, frustrating the adoptions of votes. The so-called double veto, is that a veto? Is that included here? How about if 3 permanent members, say the P3, were to vote against? Is that a veto? Then slightly more conceptually, what actually are states doing when they vote in the Security Council? There we have the famous dédoublement fonctionnel of George Sell, which proposes that states are doing 2 things in parallel. They're acting as states in their own interest, but also as members of international institutions, we expect them to act as agents of the organized international community, to enforce, to apply Jus-Cogens, let's say, in that role. And that is, of course, precisely the tension that the work of both Jennifers really underpins, that sometimes these 2 roles do not coincide. When, say, Russia vetoes a resolution on Syria in the Security Council, our suspicion is that they do so in the first sense, implementing what they see as their national interest, rather than judging as to what their role in the organized international community would best require. And here we come to the sort of second tranche of my points relating to the legal analysis of the veto, because there is some authority, some ICJ jurisprudence on voting in the Security Council, dealing exactly with this point, starting with the membership discussions in the 1950s, where the Security Council was unable to effect membership of several states. And the question was put to it whether states can make their decisions dependent on considerations other than the requirements provided for membership in the UN Charter, i.e. their political considerations. And the ICJ advised that they can't really go beyond the Charter. They should apply the terms of the Charter. But then, at the same time, they are free to exercise their political judgment as to how they do it. And this, of course, is precisely the problem here. We will not find Russia, say, justifying a veto in the Security Council in Syria with respect to its national interest. It will argue that this is an application of international law, the sovereignty of the government of Syria, let's say, or that there are other arguments. I was counsel for Bosnia in the first phases of the Bosnian genocide case, where actually Bosnia tried to bring Geneva I's issue before the court. It was desperate to overturn the Security Council arms embargo in Resolution 713, arguing that the arms embargo was contributing to genocide because Bosnia was left defenseless against a campaign of genocide and was unable to provide for the protection of its own population. It went further in a case that didn't quite take off, I think rightly so. It announced that it would bring an action against the UK for having vetoed, having opposed a resolution that would lift the arms embargo for genocide, claiming that that made the UK partially responsible for the genocide, made it an accessory to genocide. There, of course, the argument of the UK was very strong to say, look, from our perspective, our political judgment is that maintaining in place the arms embargo is the best way to inhibit further genocide, because if we lift it, there will be yet further slaughter. Also, it would mean the collapse of the UNPROFOR UN peacekeeping operations. So sometimes this kind of political freedom of appreciation, what is the best possible means to prevent an atrocity or mass atrocities or even an atrocity crime, will make it quite difficult to have this strictly legal view as to what the obligations of the sides are, because ultimately there will perhaps be a political judgment as to what is best called for to prevent genocide. None of the states that exercise the veto will accept that they're doing it in a way that would advance a breach of a jus cogens rule. Final point, how to address it further? Well, the most fundamental point for us academics, but it is a point that the UN Secretary Generals in the late 1990s, early 20s have repeatedly picked up, is this idea of rebalancing sovereignty and human rights. In my view, of course, a confusion. Human rights and sovereignty do not stand in a state of tension, they are the same. Individuals join the state so that the state can provide for their rights, ensure and safeguard their freedoms, and certainly their survival. And the idea that sovereignty is anything other than the expression of the collective identity of the population is, I think, difficult to maintain. And therefore, that sovereignty somehow bars action to preserve and protect a population from its own government is also difficult to maintain. But there are more limited attempts to try and advance the idea that this often heard invocation of sovereignty, as we've seen by the Russians in Syria and some others, actually no longer is persuasive. But perhaps that is too general a point. Secondly, increased standards. We've seen Kofi Annan, after the Kosovo issue, trying to interest the UN General Assembly in adopting standards on humanitarian intervention. Perhaps having a standard document further refined on when the veto should not be applicable. Again, Kofi Annan's initiative was rebuffed in the General Assembly. It didn't go very far, which ultimately, though happily, led to the adoption of R2P as a result of the initiatives of mainly the Canadians and some others. Yeah, to have greater clarity of the first issue I mentioned, is it mass atrocity, is it atrocity crimes, and if so, what are they, could perhaps help. Then the mechanism to apply them where the Security Council fails to make the finding that this is one of those situations. Can we have a coalition of top quality blue chip NGOs, or can we have alternative mechanisms? You remember Max von der Stoel, the fabulous late UN rapporteur on human rights on Iraq, who found that the Marsh Arabs, so-called, were at grave risk of being exterminated by the Iraqi government of Saddam Hussein, who took the initiative of approaching the UN Security Council, determining that there was this immediate risk of an overwhelming humanitarian disaster. Can we find alternative markers of the existence of a situation of mass atrocity, or in my terms, of an overwhelming humanitarian emergency? Yeah, the issue that both Jennifers mentioned moved to other political legitimizing bodies, the General Assembly, regional organizations, the threat to make the Security Council veto irrelevant, and therefore to impel states to use it less frequently. Very risky, of course, we just heard, even risky for the non-permanent members, but certainly for the permanent members, a very risky move, which has prevented the UK and others who would have been very keen to have seen action on, say, Syria, to actually support the idea to move out of the council when blocked and instead address it through the General Assembly, given that that would in the end undermine their position as a permanent member and their role. Judicial review. Again, I thought to make some remarks on that possibility, but I think my time is expiring. And therefore, let me conclude by congratulating Jennifer on a fabulous book. I am much taken by the Kogan's argument, but would propose that we also have to bear in mind the issue of political appreciation, in particular of what actions need to be taken to overturn a Kogan's violation. And generally speaking, perhaps we can also in our debate focus on the three initiatives Jennifer too mentioned, and see which one of those we should try and help to gain legs, and what additional steps we can take to add to them through cunning and brilliant ideas. Thank you.
Thank you, Mark, for you. Really, this conversation is so rich. I've been taking copious notes. I think Jennifer will try and run a little longer than 7 p.m. for us, 3 p.m. in Eastern time. Jennifer Trahan, I think you wanted to respond both to a few of the remarks made by Jennifer Welsh, as well as some remarks made by Mark. And I will say, just tagging along the last point that he raised, that the way I understand your proposition is that your suggestion, your argument is actually complementary to these other initiatives and not mutually exclusive. But please go ahead and
yes. Thank you, Federica, and thanks for what a wonderfully rich discussion. I wish we had a lot of time, so I'm going to give like my 1-minute responses to a lot of things. And Federica, you're exactly right. One doesn't really have to pick and choose. I do support voluntary veto restraint in the ACT Code of Conduct, French-Mexican initiative, and my proposals go further than these measures, which have been in existence for about 20 years and have yet to work. So in the light of the mass atrocities we're seeing, we do need some fresh ideas. So let me quickly respond to Mark first. So mass atrocities, absolutely, that's a broader formulation. You mentioned starvation. Starvation, as the Swiss well know, is a war crime because they sponsored the Rome Statute Amendment, now in non-international armed conflict as well as international armed conflict. So that would be picked up in my use. I guess because, you know, I'm doing a very legalistic argument in terms of use Kogan's, we do just say it's genocide, war crimes, crimes against humanity. We don't say it's mass atrocities. In terms of treaties, I do look under the Genocide Convention and then the Geneva. So then I'm, you know, using those formulations. The charter obligations are here where I think we have broader formulations. You know, they're protecting human rights, international peace and security. So if you want to question vetoes that seem at odds with the charter, there is where I think, you know, I don't make this argument in my book, but there is some room for like a broader analysis at that level. so, you know, you're bringing up the role of politics and the tension between being an individual self-interested actor and a more holistic responsibility. And of course, you know, states have their own interests. The ICJ recognizes this, but they are benchmarked. There's certain legal standards. So yes, of course, there are interests, but then there are Jus Cogens, charter, and treaty obligations. So I say, you know, this is the balance. In terms of, yeah, I think maybe those were the key ones. There was more, but I'm gonna move to Jennifer Welsh. So, you know, I think our problem with, you know, our first cry for veto restraint is actually within R2P. So it was puzzling to me, you went on to the French-Mexican Code of Conduct, because the first ones to articulate it is the original ICISS formulation, the Canadian Commission, saying there needs to be veto restraint in order for R2P to work. So as we've seen in Syria, the whole agenda of R2P is blocked by the veto. And I do support the French-Mexican initiative, the Code of Conduct, but in the end of the day, we have France joining the French-Mexican initiative, and we have France and the UK joining the Code of Conduct, which has 123 states parties. And by the way, no, smaller states aren't afraid of joining it. Liechtenstein, a small but mighty believer in the rule of law, was our leader. So there's no concern about states being hesitant here. They have 123 states parties. But I think in the end of the day, when 3 permanent members do not join any of these or the elders proposal, and these have been proposed for 20 years, if we have put together, there are about 6 or 8 proposals for veto restraint. You mentioned 3 of them. But they are not working. And after how long do we cross our fingers and hope the permanent members will voluntarily veto restrain themselves? So quickly, in terms of Jus Cogens, the ILC identifies all 3 genocide, war crimes, crimes against humanity at the Jus Cogens level. I think our protection when we're at the treaty level, in terms of genocide, we may be stronger protections right under the Genocide Convention, but the Jus Cogens we do have at all 3 levels. You mentioned the General Assembly stepping in, and I know Federico's remarks would have addressed this. But I think under the Charter, sometimes the General Assembly can step in and sometimes it can't. So when the referral of the situation to Syria was blocked, it created an investigative mechanism, but that can't do any prosecutions. It's solely an investigative mechanism. So what it was able to do is much less than what the Council could have done. So unfortunately, under the Charter system, there's certain measures that only the Security Council can undertake, and other bodies can't do so. So I think for the sake of time, I'll stop there with my responses.
Thank you, Jennifer. That's actually a great segue into the question that I wanted to ask, because I think there is still debate when we think about the Uniting for Peace resolution, and even the powers that the General Assembly has, or the competencies, I guess, that it has with regards to international peace and security under the Charter. I think there is a lot of debate still happening, and it's rightly so, in terms of how far do these powers actually stretch. And I would be very keen to hear Mark's thoughts on this, to say, can we really make the veto really be made irrelevant? But I guess that I wanted to ask Jennifer Welsh to comment on the kind of macro level dynamics of what are the issues that arise the moment that you utilize some of these mechanisms to shift the focus and to shift the discussion from the Security Council to the General Assembly, in terms of contesting the authority of the Security Council around issues such as mass atrocity, and where do you see any dangers, or do you see an opportunity in this, in doing this? And I think Jennifer, go first.
Yeah, I'll come to that question just very quickly in relation to Mark Weller's point about atrocity crimes. I have used that language because that has been the shorthand for the 4 acts in the summit outcome document. And so even here, although it's not explicitly stated, not all war crimes are seen as being essential to the operationalization of responsibility to protect. I think the discussion around war crimes within the R2P framework broadly suggests that they're being treated in a similar way as the gravity condition that the ICC would take. That there are particular types of war crimes along a gravity threshold that would be considered. But it is a narrower conception than the one that is in the original ICISS report. The belief was that that was required to achieve diplomatic consensus, that there was a need for and a possibility for a principle like responsibility to protect, that if you had a broader, more inclusive threshold, you would not get the same level of agreement. And that, I think, is also broadly the diplomatic understanding or interpretation of what R2P extends to. On your question, Frederica, I think on the code of conduct itself, I think coming back to, or any kind of voluntary restraint mechanisms, coming back to Mark's question, there is a question as to whether they would stifle genuine debate about the appropriate action to be taken in these kinds of situations. I mean, if you analyze the content of some of the statements of states who abstained on Resolution 1973 with respect to Libya, you will see concerns being raised about whether other kinds of means should have been undertaken to try to assess the situation in Libya. There is, I believe, often genuine disagreement about what is going to be most effective, right? That being said, there is a certain kind of interpretation of this discourse by states such as Russia, right, for example. So they bristle at the idea of responsible use of the veto, because they will claim that it is precisely acting out their responsibility to prevent actions which they see as detrimental to international peace and security. So I'm not sure how helpful the language of responsible use of the veto really is, because it can be, twisted to become part of these discussions. But I very much agree with you that that is the reality of how major states debate some of these situations. We're at a point in time where a lot of the debates among major powers are very polemical. They're very politicized. But in other instances, they often are about genuine differences of view about what mechanisms are best to take. And with respect to the issue of the institutional balance, the track record of Uniting for Peace is slightly patchy. I think it was victim to a couple of problems. One was that over time, we saw, particularly in the early days after the end of the Cold War, a renewed confidence on the part of the Security Council that it was operating effectively. And so that historic defensiveness on the part of P5 members to having any other body curtail their prerogatives was particularly strong in that period. And alongside that, you had Uniting for Peace being used by particular states in relation to the dispute between the Israelis and the Palestinians. And that, in a sense, was unfortunate, because that particular issue raised concerns about Uniting for Peace generally. But my personal view is that we are at a moment where this question of the General Assembly's role in taking alternative sorts of action is appropriate, given where we are in terms of council dynamics. And we need to look at ways in which that can be done, as Mark says, creatively and credibly. The IIIM is one of them, but also if you think back to how the Security Council came to discuss the Commission of Inquiry report on North Korea, which, it wasn't obvious that was going to happen given China's position. That again was done through some very careful diplomacy on the part of the member states of the General Assembly. So I think we are at a moment in time where it is worth thinking about the ways in which this institutional balance works or could work going forward.
Thank you so much. And just to very quickly respond and chime in with my 2 cents in this, I completely agree with you in terms of the what you've highlighted as being the drawbacks, or I guess the historical issues that have arose with the Uniting for Peace resolution. In fact, I believe that the last time that it was used was in 1997, and it had only been used, I think, 14 times before then. Now, to turn the question back to Mark, Mark, I would love to hear your thoughts in terms of what are some of the creative ways in which this conversation can happen credibly, in terms of shifting and counterbalancing institutional powers when the Security Council is not working.
Yes, I think I tried to offer some thoughts on this earlier. What Jennifer too just said reminded me, though, of a word of caution. We heard about the responsible veto, and that word reminded me of Tony Blair's famous, infamous unreasonable veto. The idea that if we don't like what another state votes against, and if it's just 1 or 2 states, then it's likely that that is actually unreasonable. So I think most of us would have thought that the decisions taken by the UK and US in that circumstance, and an argument that, say, the French attitude in that case manifested an unreasonable veto, might have been misplaced. So there is, I think, a certain element of respect that we need to bring to the table when we discuss the issue of restricting the use of the veto. It can also cut the other way. And again, we in the West, and it's mostly us, I think, who are having this debate, tend to assume that our position is the right one, and one can't reasonably have another one. And Jennifer too just reminded us of the fact that, say, China and Russia will very earnestly make quite traditional statist points in defense of their positions. Perhaps, after all, justifying that they are not, in the sense of the dédoublement fonctionnel, only defending the national interest, but they're defending their view of the world, of what international law is there for, and what balance we should strike between the key principles to which Jennifer 1 referred, as contained in Articles 1 and 2 of the UN Charter, which some things stand in a certain state of tension. So it is probably important to, in order to be credible and also have a basis of dialogue with some of those who are a bit hesitant about this, that we need to accept the relevance and perhaps, in many cases, the relevance and perhaps the justification of the veto. So what is it that would make it difficult to argue that a veto can be maintained? And my sense remains that it should be an overwhelming humanitarian emergency that cannot be averted other than by collective international action, in terms of responsibility to protect, where the government has failed to discharge its obligation or cannot do so because it doesn't exercise effective authority. So again, there, I see Jennifer 2's point, why we went over to the legal definition of atrocity crimes to get broader buy-in and have a narrow definition of the application of the doctrine. But that still gives me the freedom to be slightly sad about the need to do this in that instance. The UK, to this day, I think, in its doctrine of humanitarian intervention, does talk about overwhelming humanitarian emergency as the trigger. I don't think they have accepted that it's only crimes on this. This leads me to the point I made in terms of some of the mechanisms. Where the Security Council fails to fulfill the role of authoritatively identifying that we have one such situation, well, perhaps it is too ambitious to give Jennifer 2 the role as the advisor on R2P to make this determination as individual. But perhaps we can form a coalition of best-placed objective international agencies, which can be UN special rapporteurs, which can be other, possibly non-governmental bodies of high international standing, which can make it more difficult, at least, to argue that a situation does not qualify as, in my terms, an overwhelming humanitarian emergency that will result in huge loss of life unless urgently addressed. To try and make it more difficult to defend the argument that the state exercising the veto is exercising its legitimate freedom of political appreciation as to what best serves to prevent a jus cogens violation in Geneva 1's terms. So perhaps also clearer standards of what we understand by atrocities of this kind. Yeah, I like the idea of actually having a clearer catalogue of what alternative international agencies can do. Was it Geneva 1 who just mentioned this in relation to, say, the General Assembly, to say, yes, they could agree to establish a mechanism to monitor atrocities, to monitor violations and responsibility, although they wouldn't have been able to establish a tribunal. I'm actually not sure they couldn't establish a tribunal, but that's another big debate. So can we have greater clarity as to alternative steps and means that can be taken? Normally, if you are faced as a victim with an atrocity situation, it is the kiss of double death to find international institutions talk about international crimes and monitoring the extent of the crimes, because it tells you that they ain't going to do anything else. That was certainly the case in Bosnia and subsequently even Syria, where we saw that it's kind of the refuge of the scoundrel to say, well, we can't intervene, or we don't want to, or it's not feasible, it's not practical, it's too expensive, we don't want to risk lives, but we accept it's a horrible situation, so at least we'll monitor the crimes, and we hope that this will have some sort of deterrent effect, which in the past, unfortunately, it has never had. And that is slightly sad. So are there other steps and mechanisms which can make outside of the Security Council mechanisms or institutions and responses more visible and more likely, perhaps stronger ones? And of course, that then leads us also into the issue of forcible humanitarian action, where I do think that there is more room for action where we are faced with a genuine situation of overwhelming humanitarian emergency, which definitely we know the Security Council is not going to address, which authoritative third-party bodies have attested and determined that no other means than urgent action can prevent this kind of overwhelming disaster. But I know that not everybody agrees with this. And then I mentioned the issue of judicial review. I think somewhere in our preliminary written discussions about today, there was this proposal of having the ICJ render an advisory opinion or some such, which practically I wonder whether one can load this onto a body like the ICJ, even in an emergency procedure. That procedure, of course, is only available through interim action in contested cases. It's not likely to occur in advisory circumstances in individual cases of emergency. Could there be an advisory opinion in more general terms, advising, say, on what are the consequences of jus cogens violations for members of the Security Council? Let's think about that very carefully and cautiously, because there's a risk that this could turn out to be counterproductive, because the ICJ is so hesitant to be asked questions where the international legal system itself isn't quite ready to offer the answer in terms of the existing rules. And it might give a hedged answer to a question like that, that could actually undermine the case one is hoping to make. But as you rightly say, the ILC articles on state responsibility, there's the obligation to cooperate through international institutions. And perhaps we could do some more work. Recently, across my desk, the issue of the proposed actions of Israel in relation to Palestine arose before there was a significant change, and the question whether what states are obliged to do in response if there had been a significant violation of the Jus Cogens prohibition of non-annexation, let's say. What actually is the meaning of the obligation to cooperate, to overturn the violation? There certainly is the obligation not to recognize the outcome, the result of the violation. There's the obligation not to assist the state. And what does that mean? Does that maybe mean that in cases where no arms embargo has been possible due to a veto, that states may no longer nevertheless offer the supply of weapons or other items to the state in question? So I think there's a fair catalogue of steps and measures which we could work on. First of all, take the existing initiatives and identify all the individual elements they have, and not all initiatives have all elements, and then add to that additional ideas, and that could then be our campaigning aim, as it were, to strengthen the patchwork, which I think is the only way to address this issue. You will never persuade the permanent members of the Security Council to give up the veto. There's the issue of broadening the membership of the Security Council. Does that open up opportunities for addressing the veto? Probably not. I would expect that the existing member states will defend their position very strongly and continue to do so. But quite a number of issues that arise where we could devote our vast intellectual energies towards thinking of how we can build this kind of patchwork approach to making attempts to frustrate the operation of international security mechanisms that were meant to serve humanity into an impotent tool that really becomes discredited, as we saw a little bit in the case of Syria, sadly. Thank you.
Thank you, Mark. Again, so much food for thought, and really an hour is never enough for these type of conversations, and we've run actually 20 minutes past time. So Jennifer, I saw your comment, and I know that there are a lot of arguments you still want to make and address, but I'm afraid we're going to have to do that in a different setting and at a different time. But I really wanted to thank everyone who's participated to the discussion, everyone who has attended, and of course, all three of you for sharing your insight on this very thorny issue of the legality of the use of veto in situation of mass atrocities. Again, thanks everybody for watching, and we look forward to reconvening soon.